Of the Committee on Constitutional Amendments and Revision of Codes jointly with the Committee on Justice and Human Rights. We call the meeting to order. We acknowledge the presence of the former Secretary of Justice, Senator Laila de Lima. The committee secretary will please make of record the presence of our resource persons.
Good morning, Mr. Chairman. Good morning, Madam Chair. Madam Vice Chair. For this morning's joint committee hearings, the following are in attendance. From the Department of Justice, we have Attorney Dave Fatalia, State Counsel. From the Office of the Public Attorney's Office, we have Public Attorney Silvestre Mosing, Deputy Chief Public Attorney, and Attorney Carmela Blasa, Legal Research Service. From the Commission on Human Rights, we have the Commissioner Gwen Gana and Commissioner Amamento. From former Associate Justice of the Supreme Court, we have the Honorable Roberto Abad. And for the record, we have from the Supreme Court, Attorney Maria Victoria Guerra of the Public Information Office of the Supreme Court. That's all, Mr. Chairman.
Thank you very much. We have already recognized Gwen.
Yes.
Okay. Thank you very much. And firstly, we thank everyone for accepting our invitation this morning, and we particularly would like to give our appreciation to the Honorable Roberto Abad, the former Associate Justice of the Supreme Court, whose decision before he retired is the principal reason why we are holding this hearing today. The Committee on the Constitutional Amendments and Revision of Codes today will consider the bill that this representation filed, Senate Bill number 14, which seeks to amend our revised penal code, which, as we all know as lawyers, was enacted in 1930, became effective in 1932. How many years is that ago? 80 years ago. And, well, there has been piecemeal amendments over the years, but our revised penal code has, for the most part, remained the most extensive and significant reference work for our criminal justice system. Yet, even the finest pieces of legislation are rendered obsolete by the passage of time, in this case, 80 years. Today, however, beyond obsolescence, the revised penal code may even be attacked as inflicting cruel, degrading, and inhuman punishment, which is, as we all know, in violation of our Bill of Rights. For, in the mind of your chair, it is certainly cruel, degrading, and inhuman to imprison for 12 years and 1 day to 20 years one who is found guilty of robbery in a public building such as the Senate or a church, where the value of the property stolen or robbed exceeds 250 pesos. If it's 251 pesos, you go to jail for 12 years. Can you imagine that? Ordinary cell phone costing what? 5,000 pesos. You rob it, where the robbery takes place in the Senate. In the Senate. This is a public building. You get imprisoned for 12 years and 1 day. Isn't that cruel? And that is why in 2014, Justice, then Associate Justice, the Honorable Roberto Abad, tried to bring this to the public attention by the decision in the case of Lito Corpus versus People of the Philippines, where the good justice tried to correct the injustice and that he saw because of the obsolescence of the revised penal code. However, the majority ruled that this cannot be done except through an act of Congress. And the majority ruled that recognized that indeed there is injustice, but the Supreme Court could not do anything about it because it would amount to judicial legislation if they tried to correct the injustice at that time. It cannot, the court said, it cannot on its own adjust the outdated values set forth in the revised penal code without judicial legislation. And therefore, we are here today. We are here today, and the proposed measure seeks to accomplish two things. First, update the value of the damages used to determine the extent of the liability, and second, adjust the amount of fines. In drafting the proposed measure, we compared the two proposed approaches, the NEDA formula and the DOJ formula. Unfortunately, the NEDA is not here. Notwithstanding our notices to them, they are not here. And between these two options, however, we have relied on the DOJ formula, which yields the adjusted rates that are more objective, that is more appropriate to the objectives of the law. We believe that the DOJ formula will avoid the imposition of cruel and excessive punishment, and second, it makes the imposable fines an effective deterrent to crimes. In contrast, the NEDA formula is based on a growth rate of the nominal capital gross domestic product in 1932 against 2013, and yields rates that are twice the values generated by using the DOJ formula. Finally, the proposed measure seeks to be consistent with the most recent amendments to the subsidiary penalty, imposing subsidiary penalty, subsidiary personal liability at the rate of 1 day for each amount equivalent to the highest minimum wage prevailing in the Philippines at the time of the rendition of the judgment of conviction at the trial court. The proposed bill focused only on the adjustment of outdated values, and we did not touch on the elements of the offense. Otherwise, we will never get this out of the legislative bill because we will be debating on the elements, especially with a very learned colleague like Secretary De Lima. Ididebatihan ako dito ng gusto if I touch on the elements. So the principal purpose of the bill is only one, to update the values. That makes it a little bit simpler, and I can answer all questions rather than I would not dare touch on the elements of a crime, which will bring us probably to another decade of debate before we can get this through the legislative bill. So the proposed bill, I would reiterate, focused only on the adjustment of outdated values and left the elements of the crime untouched to avoid endless debates, and leaving the proposed measure to languish in the mills of the legislature if we touch on the elements. We hope that we would be able to pass this expeditiously. The chair filed Senate Bill 2680 during the 16th Congress, and that was at the time the Committee on Justice was chaired by now Senate President Coco Pimentel. It went through one hearing or two hearings. So for the record, the committee today adopts and makes all the position papers, discussions, and deliberations in the 16th Congress as part of the records in today's hearing in the 17th Congress. So with that opening statement, we do hope to be able to get your views on this important piece of legislation it is a bill, when it becomes law, is part of our social justice, will address the inequity and therefore is a social justice measure. So with that, we would like to yield the floor to our colleague, Senator De Lima, if he has any statement to make before we ask the resource persons. Thank you.
Thank you, Mr. Chair. Good morning to everyone. Good morning to our distinguished resource persons. I'll just be very brief, Mr. Chair. Needless to state, I'm actually in full support of this bill. This is, in fact, overdue. This is definitely demanded by the times. I think no one in this room would dispute the fact that indeed there are certain penalties embodied in the revised penal code, which rather than doing justice would actually create the reverse consequence, and we do more injustice. And that was really duly articulated on by the Honorable former Associate Justice Abad in his dissenting, very well written dissenting opinion, as well as another dissenting opinion penned or written by Associate Justice Carpio. And Justice Carpio actually referred to this as violative of the current levels of fines and penalties under the revised penal code actually is violative of the cruel punishment clause under the Bill of Rights of the Constitution. So this is very much needed. And given the fact that there have been previous discussions already on this matter, I share the aspiration of the Honorable Chair and the author, the principal author of this bill, that we need to do this as soon as possible. We need to convince our colleagues in the Senate to pass this piece of legislation. And I agree that this is easier to go through, faster and easier to go through the legislative mill rather than the bill which I actually refiled, and I'm referring to the new criminal code. And I'm sure, as stated by the Honorable Chair, that would really take several years to be able to pass. That's going to really entail a lot of discussions and debates because it's actually an overhaul of the archaic 82-year-old revised penal code. I would have some comments later in the course of the discussions also on some, but in principle and well, I'm actually giving my full support to this bill, and I would wish the Honorable Chair and the principal author to consider me as a co-author of this piece. Thank you.
Thank you very much, Senator De Lima. Yes, it will be an honor and much certainly will add strength to the bill with you if we can include your name as a co-author of the measure. Having said that, we shall now proceed, and with the permission of our guests, may we first call on the Honorable Roberto Abad, who started all of this, to give his comments on the proposed measure. Thank you.
What can I add more after all that you said concerning this proposed bill? I think you have seen the fairness and justice that it will bring about, because imagine that the penalties that in 1930s were pegged on the values of 1930s, and as I said, if you steal a sack of rice, the value in 1930 is 450 pesos. So you go to jail for the period letters, I think, well, today the value is about 1,800 or 1,900 per sack, yet you suffer 20 years for stealing that same sack of rice today, if you base it on the value of the sack of rice. Whereas it should, if you adjust for value, that will be only about 2 years and 4 months So it's terrible.
Can you repeat that? I didn't catch it quite well, Justice Abad. On the example that you stated, insofar as the rice is concerned.
I will have to, I'll submit a paper on that rather than, because I just list it down.
The sack of rice.
450 per kaban in 1930. Today it's, I don't know, 1,900 or something per kaban. So the price before is less than 1% of the price today. Yet the penalty is, well, peg on the price. That's what I mean. I'm glad that you have seen the justice in this and the fact that many of our people who have been convicted have gone to jail and spent so much time. The greatest, I mean, the ones who suffered most here are really those who are found guilty of qualified theft when they go to jail for 20 years for stealing lipstick worth 150 pesos from their employer, something like that. So it's really quite unjust and has to be adjusted already. Thank you very much, Mr. Senator.
Thank you, Justice Abad. The CHR, can we have your comment on this?
Good morning, Your Honors.
Yes.
We are very supportive of these measures because we believe that these are long overdue and it will surely serve justice and promote human rights, especially of the marginalized. We would like, however, to put on record certain comments. We believe that SB 14, the amount specified, are actually measured to counter the gravity of the commission of the crime. So we believe that it should indeed be passed soonest because it will definitely promote the justice in our midst. And as to SB 1227, our comments would be that one, the definition of the child under RA 7610, in order to make it consistent with the law, with your proposed measure, we would suggest that the minor under Section 12 be instead changed to child in the measure, ma'am. And
We are not, precisely, we said we decided we will not touch
okay.
that first because the substance of the provisions of the penal code will entail a lot of debate. So
Okay.
itabi muna natin yan.
Okay,
We'll
yes.
next consider
Yes,
it.
Your Honor. We'll just submit
yes.
later on the position
Yes,
paper on the
yes,
matter. Okay.
yeah.
Otherwise, Your Honors, we are very, very supportive
Yes.
of the measures. And it's about time.
Yes, the Department of Justice.
Good morning, Your Honors. We will submit also our official position paper on the matter, Your Honor. But personally, I also believe that the changes is timely and required by the times, Your Honor.
What date are we today? We are January 18. Can we have it before the month is over or next week? Because we want to sponsor this as soon as we can. So if we can, when can you file it?
As soon as I'll try my best, Your Honor, to file it as soon as possible. I can commit on a specific date, Your Honor.
Sorry?
I can commit on a specific date, Your Honor, but I'll do it as soon as possible, Your Honor.
Yeah, well, we will submit our committee report on a week from now, January 25, and we will sponsor this Monday after that 25th, so about January 30.
Today's 18th.
Yeah, we will present this, the committee report will be sponsored, our timetable on January 30. If there are no specific and very strident opposition, we will do so, but I would wait for, I will hope that the position paper of the Department of Justice can be submitted, let's say before, by the weekend or Monday. Can we do that? Sorry?
I'll do my best, Your Honor, but personally can't commit on the date.
Sorry,
Your Honor.
sorry?
Personally, I can't commit on a specific date, but I'll rush this matter, Your Honor.
Yeah, okay. Yes, from the ombudsman, yes, you have encountered a lot of problems on this. Yeah, please use, Attorney
Good morning, Your
Dasmariñas.
Honors. Uh, I'm sorry to say, Your Honor, this was just assigned to me yesterday afternoon. And I think, sir, I have to coordinate with our head sa OLA, sir. And we'll check on the stand of the office. But I believe the Office of the Ombudsman agrees with the revisions or the adjustments of the values.
The, so we
We
will
will
be
also
submitting a
yes, sir.
position paper. Hopefully, we can have it by Monday at the latest.
Monday, sir?
Yes.
Yes, sir. I will coordinate with our head, sir, of
Okay.
OLA.
Sige. Okay. Let's just finish the number. Okay. From the POW.
Yes, Your Honor, please. The Public Attorney's Office is fully supportive of this proposed legislation, and as early as the past Congress, we have already indicated our support to this measure. So much so that it impacts more on the clientele of the Public Attorney's Office, who are mostly charged with these property crimes.
And would you be in a position to state on the record how many convicts who are serving sentences right now would be benefited if we pass this measure? Give us an idea. Maybe. Oh, yeah. Your microphone, please. Just a rough, without binding you to it. Just a rough, off the top of your head. Ballpark figure. Ilan kaya ang to really to update this and make it more just? How many would be benefited?
Mr. Chair, just to guide
Yeah.
the Deputy Chief Public Attorney, we have to remember that the current jail population, insofar as the jails are under the Bucor, that's about 48,000 plus convicted prisoners. And while those under BJMP, it's more than the 48,000 under Bucor. I think it's a total of 120,000 something. Both BJMP and Bucor. So what percentage, more or less, it's just again a very rough estimate, just recalling a data that I was just looking at last week. So any percentage of that number, the detention prisoners, of course, are under the BJMP, except for those convicted of imprisonment of 3 years, less than 3 years. That is BJMP, less than 3 years. More than 3 years and up, 3 years and up, that's Bucor. One and convicted. Yes.
Of those convicted or detained for criminal cases, let's just say that the POW handles half of those, half of these cases.
Presented by private
And
counsel.
maybe more than half of this would be property-related crimes. So I cannot give the exact figure at this time, but we have records of the cases handled.
If your office, please, can make a submission also to
Yes.
guide in the plenary deliberations.
Yes,
As reference. Thank you.
Yes, very well, Your Honor, please.
Just a guess, given what you just mentioned. Would 50,000 be a fair figure that will be benefited from this, both from the BJMP and the National Believe It?
Definitely, yes, Your Honor.
50? I'm lucky. So potentially, 50,000 of these indigent prisoners can be freed once we pass this law? Is that what you're saying? Given the fact that the...
Benefited to some extent, perhaps, although not necessarily all can
Yeah.
maybe
Yes,
freed. But
maybe,
to some extent, because
yeah.
it again depends
Yes.
on the status.
If
and
the penalty is lowered because of the adjustment, then
So
some would benefit.
roughly, we can safely say 50,000 will be benefited, but we cannot say that 50,000 will be released.
Yes,
Is that correct, Attorney Musing?
yes, Your Honor, please.
Yeah, so at least we get, but if you can submit to the committee a more precise figure, because that would help us in convincing our colleagues of the urgency of this measure. So well, yes, Senator De Lima.
Just one point, Mr. Chair. This is just an observation, and I'm sure there is a explanation. I noticed that most of the amounts were adjusted to 200 times from its existing
yes.
RPC provisions, because the ratio, I believe, is 1 to 200.
That's right.
But there were some that were not adjusted according to that ratio, but in fact lower. 1 is to 40, 1 is to 100. May I just cite a few examples? Article 114, treason. The RPC amount is 100,000. The proposed adjustment is 4 million. So it's a multiplier 40. Article 136, conspiracy and proposal to commit co-data. RPC amount 8,000. Proposed adjustment 1 million. So the multiplier is only 125. And there are a few that the multiplier is just 100, like Article 209, the betrayal of trust by an attorney, multiplier of 100. Article 217, malversation of public funds or property, multiplier of 100. Maltreatment of prisoners under Article 235, only a multiplier of 16. So there are a few. I can submit a list to the Office of the Good Chair. May we just be enlightened, and probably for purposes of plenary deliberations, this might also be noticed by our colleagues as to the basis why these felonies were distinguished from the rest, which applied a general ratio of 1:200.
Thank you, Senator De Lima, for that point that you raised. For the record, as we said earlier, we used the DOJ formula. And the value of the property or damage or the amount involved in the crime is divided by 2 pesos and 50 centavos, which was the minimum wage rate in 1930. And on which basis the penalties were based. And we, from that division, after we get the result, we multiply that by 500 pesos, which is the current highest minimum wage rate, rounded off to the nearest 100. This is also we use as a guide Republic Act 10159. 10159 is the one that set the rate on subsidiary penalty, so that under the Republic Act 10159, if the convict has no property with which to meet the fine mentioned in paragraph 3 of the preceding article, he shall be subject to a subsidiary personal liability at the rate of 1 day for each amount equivalent to the highest minimum wage rate prevailing in the country at the time of the rendition of judgment or conviction by the said court. So that is why we use the minimum wage rate, which today is 500 pesos per day. That is the formula of the Department of Justice. Now, during the deliberations of the technical working group, some items were adjusted because to apply the 1 to 200 ratio would yield very high numbers. This is why those provisions were adjusted differently. That's the principal reason, because to strictly apply the 1 is to 200 would yield a very high number. So with that, if there are no other issues, if the Honorable Abad would find time to submit a position paper, we would gladly we would be very appreciative in order to guide us in our debates. Any other comment? So we expect the position papers to be submitted by the Department of Justice, by the Ombudsman, not later than the 23rd of this month. Also, the Public Attorney's Office can submit to us, and on Justice Abad, in your own time, if you can do so. We don't want to impose on you as. Yes, if you can voluntarily submit it, it would be deeply appreciated. So with that, unless there are other matters, any other? We would now consider the hearings terminated, and let me reiterate that we adopt all the position papers, discussions, and deliberations in the previous Congress when Senate Bill 2680 was deliberated upon as part of the proceedings in today's committee hearing. With that, unless there are other issues, concerns, statements to be made, the chair will now consider the Senate Bill number 14 submitted for the deliberation and decision of the committee. Thank you very much. The meeting is now adjourned, for the record.